So thank you very much for inviting me to the University of Texas to speak about this issue of resource extraction and human rights, and in particular about violence against women in this context. It's really great to be here. I have really appreciated the very warm welcome, and I'd like to extend a special thanks to Daniel, to Julia, to David, Spence, and to Holly Heinrich, who I haven't met yet, but hi. Yes, and to Sarah Klein for taking such good care of me today. So the regulation of transnational corporate activity, and specifically resource extraction, is a very pressing global issue, and it's also a very pressing issue in Canada. We are, in Canada, host to 75% of the world's largest mining or exploration companies, as well as some of the major oil and gas companies. And so consequently, our economy is very heavily reliant on both domestic and transnational resource extraction. At home, the public is aware of the oil sands, which I'm sure you've all heard of, the Alberta oil sands, and the problems of the controversy over those oil sands and trying to be able to get the oil to places it can be shipped, so the pipelines that are going to be built. But few people know anything about the human rights or the environmental impacts of resource extraction that happens in Canada and that happens abroad by Canadian companies. So violence against women, sort of in the business and human rights discourse and scholarship, there's been little focus on the differentiated impacts of resource extraction on women and men. And in the development of intergovernmental and multi-stakeholder standards, there has also been little perspective on this. And this is despite the fact that violence against women, including sexual violence, is unfortunately a regular feature of resource extraction that is perpetrated in a variety of circumstances. So there is, of course, resource extraction that happens in the global north, in the Peace River region of British Columbia and Canada, northern BC, and also in the Bakken oil fields in North Dakota in the USA. Probably didn't have to say USA because you know where North Dakota is, where there are large numbers of highly paid men who are living in these so-called man camps with not many places to spend their money. There's a lot of substance abuse, and there is a consequent increase in domestic violence, murders, aggravated assaults, and rapes, human trafficking, and robberies. Also, in the global south, in countries like the Democratic Republic of Congo, resource-rich countries, there's violence against women that was widespread during the conflicts that took place, the conflicts over natural resources over the last 20 years, and the widespread impunity for those crimes. And today, even though those conflicts are more or less over, women artisanal miners continue to suffer significant discrimination, oppression, and violence, including sexual violence in the course of their work. The United Nations Special Rapporteur on Violence Against Women has also reported similar discrimination and violence in the South African industry against women miners working as employees of mining companies. But I'm going to focus on a different context. I'm going to look at transnational resource extraction, which often involves a company from the global north, so a Canadian mining company, for example, or oil and gas company operating in the global south. Transnational corporations are much more likely than other business actors to operate in complex socio-political environments, in remote locations, where governance may be weak, where land title might be in dispute, and where there may be civil unrest or conflict. And communities affected by resource extraction may also engage in resistance to transnational mining or oil and gas projects that may pollute their water or result in their involuntary displacement, loss of way of life, and among other things. They also may employ, the companies may also employ security forces, whether they are public security forces, so military, or private security forces, which in the course of suppressing local protest and or protecting these extractive projects engage in what amount to grave violations of human rights. And they might repress peaceful protest by violence or criminalize protesters. They might kill, maim, torture, forcibly evict populations, and engage in sexual violence against women. So violence in the context of resource extraction and in this transnational context is often present. There was a report that came out a few weeks ago by the Justice and Corporate Accountability Project, which is a clinic at the Osgoode Law School in Canada, in Toronto, Canada, that reported 100 incidences of violence associated with Canadian mining projects in Spanish-speaking Latin America alone between 2000 and 2015. And these were only the incidents that they could find two different sources talking about, credible sources that talked about these incidents. So it is probably the tip of the iceberg. Global Witness has also noted that there was a significant increase in violence against environmental or land activists in 2015, which they said was by far the worst year on record, and that most of the killings in 2015 were related to extractive projects. So 42 of the killings in that year, which was a 70% increase from 2014. And rape, of course, is among these types of the violence that is committed against such communities. So I want to give you 3 examples of Canadian corporations that have been engaged in violence against communities, and that has included violence against women, in particular rape. Now, certainly Canadian companies are not the only companies that have been associated with this type of with rape or gang rape in their extractive projects, but they have been implicated, Canadian companies, in some of the most notorious examples of rape and gang rape that were perpetrated by security forces in protecting the assets of a resource extraction project. So I want to talk first about Sudan and Talisman Energy, which is a Canadian company that was operating there between 1998 and 2003 in the context of a violent civil war, a violent but low-grade civil war. They had a subsidiary operating there as a 25% partner in what was called the Greater Nile Petroleum Operating Company. And this was before the conflict in Darfur ignited. And during Talisman's tenure in Sudan, the oil exploration and development areas became the main theater of combat. And this is an area that is now South Sudan. And it was combat between the government of Sudan and rebel groups. And the government of Sudan was employing a scorched earth policy in and around the oil fields in order to protect the infrastructure from rebel attacks. So they were forcibly displacing the populations with the idea that they were harboring rebels. And the infrastructure was being used for the raids on these villages. First of all, they were sending in helicopter gunships, then they were sending in Antonov bombers. And this was being followed up by ground troops that were basically Arab militia that were going in and inciting terror in these villages. And they did this in a number of ways. They rode in on horseback, and they would brutally murder people, rape women, abduct women and children, loot, and then burn the villages to the ground. So the Canadian government sent an independent mission. The independent mission came back and said, yes, this is happening. The reports that you heard are happening. Oil is fueling this war, and the Canadian government said it had no legal means to sanction Talisman Energy for operating there or its complicity in these violations. There was an Alien Tort Claims Act case brought against Talisman Energy that was dismissed after 9 years, and Talisman always in Talisman's favor, and it always maintained, of course, that there were no grounds for these allegations. Now here's just I was on this mission, so this was one of the groups of women that we talked to, and they said to us, the government of Sudan used Antonov's helicopter gunships and machine guns in the attack. They killed many people, raped women, looted our tukals. We think the forces took many of our children because they disappeared and we never found their bodies. So terrible abuses going on, of which rape was one of those abuses. Another incident, which is quite well known, is also a case that's being brought against Hudbay Minerals Incorporated in Canada, where 11 Mayan Quechua women are bringing this suit. They've accused the company through its predecessor, Sky Resources, of negligently directing and supervising private security personnel of the Phoenix Mine Project, who forcibly evicted certain Mayan communities from contested land to which these communities later returned. They had returned and they were being evicted again by the security forces and the police. And the plaintiffs allege that along with the police and military, the company's private security forces arrived at the village of Lote Ocho and trapped the plaintiff women in and around their homes. Some of the plaintiffs were seized as they tried to flee with their children, while others were trapped inside their homes as they tried to gather their belongings. All the plaintiffs were each then physically assaulted and gang raped by groups of men consisting of the Phoenix security personnel, members of the police, and members of the military. Now, this case is one of the first cases it is the first case in Canadian courts to move beyond the jurisdictional stages and to the merits. And so there's a case now in discovery, but we don't know whether it'll be settled or whether that will come out with a decision in favor of the plaintiffs. The third example is a case is Barrick Gold. This might be more well known, one of the largest gold mining companies in the world. They have acknowledged, or the company has acknowledged, that there have been violent assaults against both men and women in local communities, including rape and gang rape of women that have been happening over many years in its Porgera mine in Papua New Guinea. And this is a quote from a report that was done by the Human Rights Clinics of Harvard and Columbia. It says that many of the sexual assault allegations presented have involved a similar pattern of conduct. Mine security guards, sometimes in groups of 5 or more, would encounter a woman or group of women while patrolling on or near the mine property. They would engage the woman with threats and violence, then rape her. Many sexual assault victims describe brutal assaults in which they were punched, kicked, or beaten with guns, sometimes resulting in severe injuries. In a number of cases, women reported being forced to chew and swallow the condoms used by the guards during the rape. So, rape is only one type of violence that's perpetrated on these communities, but it is, in my view, a particularly contemptible form of violence. Nonetheless, while men can be victims of rape, women have always been the main targets, or the primary target of rape. And the UN Special Rapporteur on the situation of human rights defenders has noted in his most recent report that just came out a couple of months ago, I think, that sexual violence is particularly used to silence human rights defenders, and that in Latin America, for example, he says, these women defenders are one of the most threatened environmental human rights defenders owing to the nature of their human rights work and to their gender. Studies have also shown that rape itself has greater mental health impacts on women than other forms of violence. So, for example, one study that examined the differentiated effects of physical and sexual violence on women in intimate relationships found that women who experience both physical and sexual partner violence report higher levels of PTSD than women who just are physically abused. And even within the context of ongoing physical violence, the experience of sexual violence directly results in more severe PTSD. Rape can also have significant social implications for the victims. In certain communities, women can be cast out of their home and out of their village. So the victims of gang rape that was perpetrated by Barrick Gold's forces in Papua New Guinea reported these very effects, including shunning by their families and communities, demands of divorce and return of bride price, further brutal physical violence by their husbands. And so, as Deacon and Badge argue, rape victims then suffer twice. First, they suffer the rape, and then they are condemned by a patriarchal community. The acts of gender-based violence perpetrated in the context of transnational resource extraction aren't committed in a vacuum. They don't just happen because that company has come in. Rather, just like rape that happens in times of conflict, they are the direct results, as Jackie True has noted, and reflections of the violence and discrimination and marginalization that women face in their everyday lives and communities. And there are many contributors to structural gender inequality, including poverty, economic status, access to education, access to health care, and impunity for perpetrators of violence against women. Jackie True also notes that globalization has increased poverty and marginalization in women. So even though globalization has resulted in the fact that more women are in the formal workforce, because of it, it has also left unchanged and has also probably supported the underlying patriarchal structures that perpetrate women's inequality with men and their susceptibility to violence. And international financial institutions in funding projects in the Global South have also not targeted the gendered nature of underdevelopment, which exacerbates poverty and inequality and has therefore helped to maintain and aggravate the conditions in which violence against women persists. So, in my view, international law is, of course, intimately linked to the neoliberal global economic system. It helps to entrench global power relations that support and exacerbate these conditions that lead to violence against women through the regulated and unregulated spaces that it creates or maintains. There's something in the business and human rights discourse that's called the governance gap, which I'm sure if you've read a lot of things about business and human rights issues, you've probably come across. But the governance gap is alive and well in international law. Neither general international law nor international human rights law imposes direct legal obligations on transnational corporations that are to respect human rights. There's no clear obligation on home states, like Canada or the United States, for example, to regulate their companies when they're operating overseas. Some states have considered regulation and rejected it, although there is regulation being considered in France. And the UK has enacted the Modern Slavery Act, which tackles one part of this problem. But so far, there's no state that has enacted a general legislative framework that requires corporations to respect human rights when they're operating transnationally, to undertake human rights due diligence, and including a human rights impact assessment before investing in a state, and then engage in ongoing human rights due diligence, or legislation that puts in place effective compliance and complaint mechanisms for people who are victims of corporate-related human rights abuses. There is, of course, a patchwork of legal mechanisms that could be used to hold companies accountable, like shareholder proposals, socially responsible investing, whistleblowing laws, transnational human rights lawsuits like the Hud Bay case, for example, and the case against Talisman under the Alien Tort Claims Act. But none of these on their own is able to effectively regulate corporations when they're operating overseas. So what international law presumes then that the host state, of course, is going to regulate these entities. But there are, of course, a number of reasons, quite a wide range of reasons, why those states may not do it. They might want to attract investment, for example, and not want to impose regulatory restraints on corporations. They might lack the effective institutions to govern transnational corporations. Governments themselves may be perpetrators of the abuses in which they're complicit. So when there are public security forces involved in violations, that is the government perpetrating them. And also there's the impact of international trade and international investment agreements, along with interventions of international financial institutions like the World Bank and the IMF and the International Finance Corporation, that have restricted the capacity of states to regulate foreign investors, to protect human rights and the environment. So we have, filling this governance gap, soft forms of regulation, like the Guiding Principles on Business and Human Rights, the OECD Guidelines for Multinational Enterprises, the IFC Performance Standards, voluntary principles on security and human rights. And states have taken this on as the way that is supposed to be the way to regulate companies. So Canada, for example, has a 2014 corporate social responsibility strategy, and it's called an enhanced strategy because it's supposed to be better than the one we had in 2009 for the extractive sector. And what it does is it says we expect companies to respect human rights, but it doesn't define what that means. It doesn't refer back to the UN guiding principles on that. And it then goes on to suggest that companies align their operations as applicable with either the OECD guidelines, the UN guiding principles, the IFC performance standards, or the voluntary principles in business and human rights. And all of those are very different, and some of them deal with human rights issues and some of them don't. International law, of course, also turns a blind eye to what we call the economic reality of transnational corporations, which are these corporate groups that operate as an enterprise, but as a matter of law, they are considered all separate legal persons, each of which is supposed to be governed by the jurisdiction in which they operate or are incorporated. And domestic law, of course, has followed suit. We treat in domestic corporate law as well corporations as these corporate groups as a group of separate legal persons. Now, I just wanted to show you what this actually means in terms of structures. So if you have a Canadian mining company operating in Colombia, for example, often, and this is a very simple diagram that doesn't really show you the complicated corporate structures, the Canadian mining company will be operating here, the subsidiary will be operating in Colombia. Somebody wants to sue the Canadian mining company in Canada, but in fact it was the subsidiary that committed the abuse. It's very difficult unless you can show that the parent company independently was actually perpetrated the acts or omitted to act in a way that they should have to show that the parent company should be liable. Also, if they can sue this subsidiary in Colombia according to Colombian law, they may not be able to actually recover any damages from it if the corporation transfers money to other parts of the corporate group. So it can be very difficult. Now that is the very simple structure. Here is Barrick's corporate structure, just to show you how complicated it is. So that shows you how the difficulty that can be done. And these corporate and the other thing is, it's not just corporations. There are also other types of partners that are not corporations that operate with these big corporate groups. So this governance gap is not an oversight, in my opinion. Neoliberal globalization has enabled strategic regulation and deregulation, and it reflects the current historical and global power relations at play. States, and in particular northern states, have used international law in a way to establish a market-friendly legal system that facilitates and protects corporate activity through international economic law, which is international trade, international investment law, and which addresses the governance of transnational corporate-related human rights abuses only through these soft mechanisms that are very difficult to kind of enforce in ways that provide remedies for victims. International law's failure to address transnational corporate activity therefore creates another level of unregulated space that supports directly or indirectly the global and domestic structural dynamics that maintain and aggravate violence against women. Now, not only is that the case, but the governance gap itself is gendered. So Hilary Charlesworth and Christine Chinkin, two very well-known feminist scholars who wrote the book called The Boundaries of International Law, have demonstrated how the gendered structure of international law marginalizes or excludes women. And their insights are apposite in this context. They say that states use soft law structures for matters that aren't regarded as essential, so for things that they don't see as important. So if it's not economic, it may be less important. Or where they are reluctant to incur binding obligations. And we see that a lot in international environmental law as well. This use of soft law, Chinkin and Charlesworth argue, has the effect of doubly marginalizing women. So women's rights are perceived as soft issues in international law, and then they are responded to by using these soft modalities of lawmaking. So states appear to accept that it's an important issue, but then they minimize their legal commitments. The governance gap actually furthers this marginalization in two interrelated ways. First, by creating yet another site of deregulation that contributes to the structural inequalities that maintain and facilitate violence against women that I just talked about. And then also because of their gender blindness, or you could also say myopia, the gender blindness of the multi-stakeholder and intergovernmental initiatives that are supposed to fill this gap, which fail adequately to address the differentiated impacts of corporate activity on women, and in particular the role of corporations in sexual violence. Now, the guiding principles are a case in point, the United Nations guiding principles. Just in case none of you have heard of these were developed by the Special Representative on Business and Human Rights, Harvard Professor John Ruggie. He started his mandate back in 2005 and then developed a policy framework, and then he had his mandate renewed and developed the guiding principles to operationalize the policy framework. And the guiding principles rest on three pillars. They look at first state obligations, then business obligations, and then the issue of access to a remedy. So the state obligation to protect human rights of individuals from the acts of private actors like corporations, the business responsibility, which is a non-binding responsibility to respect human rights, and then access to an effective remedy, although he left out effective remedy, he just said remedy. So in 2008, when he was about to move forward and operationalize the policy framework, he was told by the Human Rights Council that he had to integrate a gender perspective throughout his work. So the draft guidelines that were put forward just about 4 or 5 months before the final ones came out had little in them beyond a recommendation, and this was in 2010, that they should be implemented with due regard to gender considerations at the beginning. It was at the beginning, and very little else within them. So there were people who commented on this, and he took some of those comments to heart, and the final version does mention the differentiated impacts of corporations and the risk of sexual violence, but it doesn't do it in a sufficient way. So there are two recommendations to states and two recommendations on the differentiated impacts of corporation, one to states and one to corporations. Basically telling states, first of all, you need to support companies and provide them with recommendations on how they can consider the impacts on the different impacts on men and women. And then to corporations, it alerts them when they're engaging in human rights due diligence that to pay attention to the heightened risk that that some people will be more vulnerable and that different risks are faced by men and women. On sexual violence, there's no specific recommendation to corporation, but to states. But to states, they recommend that they ensure that corporations that are operating in conflict-affected areas should that where corporations operate in conflict-affected areas, states should ensure that they assess and address the heightened risk of abuses, paying special attention to both gender-based and sexual violence. So this, of course, is very important that we've found this in the guiding principles. However, there's no suggestion in the guiding principles that there is a no-go zone for companies, that they should, where they're going to become engaged in grave violations of human rights, including this kind of sexual violence, that they shouldn't go to this place. And there's no discussion of the risk of gender violence outside of conflict, which of course it happens all the time. And finally, and this is a problem that is indicative of the myopia of these types of mechanisms or these types of norms, the UN Guiding Principles divide human rights that corporations are expected to take into account when they are determining their obligation to respect human rights, or their responsibility to respect human rights. They divide those rights into two categories. And the first category are those rights that corporations should take into account in all circumstances. And these include what's called the International Bill of Rights, so the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Universal Declaration on Human Rights, and the ILO Declaration on Fundamental Principles and Rights at Work. And then there are what they call the additional standards. And that is what corporations may need to take into account in particular circumstances. And these include women's rights, children's rights, the rights of persons with disabilities, the rights of indigenous peoples, and other minority groups. So this division into these two categories of rights is incompatible with, and it undermines the accepted doctrine of the indivisibility and interrelatedness of all human rights that was articulated back in 1993 in the Vienna Declaration and Program of Action. It also suggests that with respect to these second category rights, these additional rights, that corporations really don't have to take them into account in their everyday operations. They're probably not relevant. And so with respect to women, to say nothing of the other groups that are left out as well, this then again feeds into these structural inequalities that already may exist in host states and the communities in which these corporations are operating. So just some conclusions. There is some hope after that really probably very depressing talk. There is some hope. There is law that's being developed in a variety of sites, global and domestic. There's a treaty process that is going on at the United Nations. A couple of years ago, the Human Rights Council passed a contested resolution to begin to establish an open-ended intergovernmental working group with a mandate to develop a treaty to regulate in international human rights law the activities of transnational corporations and other business enterprises. It is a contested process, mainly supported by developing states. Europe is on the edge. They may engage with it. But the US is not, and Canada has not, since we've changed government, has not said what it's doing. It's in the early stages, and it's not clear what kind of treaty is going to be there, but of course they will have to take into account this sort of gendered nature, or the differentiated impacts of corporate activity on men and women, and the potential for corporations to become complicit in sexual violence. However, it also is a highly complex task. They don't even know what type of treaty, whether it's going to be a comprehensive, a framework treaty, or one comprehensive treaty, or a series of treaties. So that is unknown, and it's also a highly political arena in which it's being developed, as treaty lawmaking always is. At the domestic level, France, as I mentioned, is considering a law requiring human rights due diligence reporting on supply chains. In Canada, there are civil society groups that are pushing for the establishment through legislation of an ombudsman who will have investigatory powers, so a proper independent a complaint mechanism. And the only hope that there is that the Liberals who are now in power did promise in their election when they weren't in power and weren't even the opposition to support an ombudsman office. And it seems like the Prime Minister is in favor of this. It's just a question whether you can get all the government on board. In domestic courts, there are things that are happening. So we've talked about the Hudbay case, which is in discovery now, so it has moved forward. And there's also another case in British Columbia that is the first case ever to go forward where the court found that Canada was the most appropriate forum to hear this complaint. So it got beyond the forum non-convenance motion that the company put forward. The guiding principles on business and human rights are not being completely ignored. Businesses there is uptake from business. They are talking about this responsibility to respect human rights. States are developing national action plans, although those have been far from spectacular so far. BEREC developed the remedy according to the United Nations guiding principles in order to compensate the rape victims and give them money, but it didn't give all of the rape victims the same amount of money. Some that were represented by Earth Rights International were given 10 times the amount that most of the other women were given in compensation. And they also required the women to waive their right to sue BEREC in relation to, for any compensation in relation to the rapes. And the North Mara mine, which is in Tanzania, that is also BEREC's mine, has had the same kind of violence, including gang rapes. They implemented the same kind of compensation and complaint mechanism, which has had the same kind of problems, and the gang rapes are continuing there. But, so that's on the norms, but these soft law mechanisms are being used in civil suits like the Hudbay case, for example, to demonstrate an existence of duty of care of the company, that in fact, when they sign on to these things, they are indicating that they understand that there are risks, that these risks are foreseeable. So that is something positive. Also, the women are not simply victims, some of the women in these cases. They are actually fighting back. They have, in the Cal and Hudbay case, they have brought a claim in a Canadian court, and they are pursuing it. For the Barrett Gold mechanism, the Porgera women were at the UN Forum last week on business and human rights, and were speaking, announcing and saying to Barrett, we want proper compensation. So they are not letting this rest. So just in closing, I just wanted to say that the structural inequalities that create the conditions for violence against women and their exacerbation by globalization is, of course, a very complex problem, and regulating corporations is not going to solve that problem on its own. But it would be a small step. If you do have legislation in place, either home state legislation or a treaty that requires home states or imposes obligations directly on corporations, that would require them to engage in due diligence prior to entry into a host state, require them to screen and oversee their security forces, that may prevent some of the sexual violence. And if such legislation were in place, it could also provide effective criminal and civil remedies, which would mean that these women would be able to seek adequate compensation. And it would also create some sort of accountability for these companies and their complicity in these grave violations. Thank you very much.
Well, that doesn't help. Let's see. So are we going to turn this off or just close it? All right. That won't help this, though, will it? Yeah. All right, good. First, let me thank Dan Brinks and Rapoport Center for inviting me to participate today. I'm glad to be here, and I want to thank Professor Simons for coming all the way down from Canada. I know that in my hometown of Rochester, New York, they got dumped on. You probably dodged a snowstorm, I imagine, coming down here.
No,
Yeah.
Just literally by minutes.
Yeah, yeah. So we appreciate that, and I really enjoyed reading the paper. It's obviously could not be about a more serious subject. As Dan said, this is not really in my wheelhouse, international law and international human rights law. So I'll try to say something that I hope is reasonably intelligent that comes from my perspective, which is as a domestic energy regulator, regulation expert. However, I should also add that I've done some corporate social responsibility executive education teaching for oil companies. Mainly two very, very large oil companies, none of which were mentioned today, thankfully. And so over the last 9 years or so, I've gotten to talk to both public governmental affairs people, but also project managers who oversee these projects in the developing world. And so that also shapes my perspective a little bit on this. And I take as the sort of main point, I'm going to comment on the paper because the paper is what I prepared to comment on, although I think pretty much your remarks track the paper, added a few things. But what I take as the main point of the paper is it's essentially a plea for stronger international legal institutions that will create binding obligations on companies working in these areas to better prevent and police sexual violence against women. And so the paper outlines the problem, as we just heard, and the case for the weakness of existing institutions, and also a diagnosis of why those existing institutions are weak, which Professor Simons traces really to what I tend to think of as, well, it's a combination of things, but ultimately it's sort of the Washington consensus. The combination of globalism and neoliberalism sort of dominating international legal institutions, or the theory behind international legal institutions, which creates a kind of race to the bottom for these companies, or for these countries rather, and weakens enforcement and policing of this very important problem. So that's the thesis that I wanted to comment on. And let me just say that I begin by saying that I'm persuaded by the paper that stronger binding regimes would improve the lives of women who are targeted in this way, probably without imposing terribly significant costs on either the companies or the local governments, or other locals for that matter. I think leveraging companies and leveraging these very high stakes transactions, that is expert investor-owned oil companies being contracted to develop a very valuable resource, is probably a pretty effective way of exerting leverage over host governments and host societies, which Professor Simons properly characterized by weak governance. And so these are very important deals to these countries, and so to the extent that international law could leverage their desire to develop those resources in this way, it probably would be, I'm sure it probably would improve conditions and reduce the probability of these sorts of horrific crimes happening. My reaction to the argument is that I'm persuaded as to the conclusion, as somebody who comes from outside this literature, to me, it seemed like parts of the argument were being made at about 30,000 feet, probably because I don't understand the literature fully. So I'm going to comment about the parts of the argument that I wish were made at ground level from my point of view, so I can understand, so I can sort of perhaps provoke a discussion about, which hopefully won't benefit only me as somebody from outside this field, but raises the sort of issues that I would have liked to have seen unpacked a little bit more. In my field, energy regulation, we talk all the time as well about the fact that markets, energy markets, free markets, have normative biases to them that can be very opaque at times, particularly the concept of efficiency within economics can be loaded with normative implications that I think economists don't always acknowledge, and that law and policy are ways that we as a society collectively choose to deviate from the allocation of costs and benefits that the market gives us. And that's essentially, I think, the argument that we're talking about here. I make similar arguments with respect to electricity markets here in the United States, and for that matter in Ontario as well, where they have competitive electricity markets. And so I think that's a general truth that I fully accept here. And that general truth is the level at which I see this argument being made here. And so parts of the specific argument, the specific case, I would have liked to have seen buttressed a little bit more or a little bit more strongly, and I'll explain what I mean by that. So we begin, the paper begins with the idea that violence against women is inherent or common feature of associated with natural resource extraction, which is really an argument about sort of frequency or a connection, a necessary connection there. And I think there is a connection there, and there is a frequency that is a frequency that's higher than in other contexts. But the way the paper is written sort of implies a connection that feels stronger than the one that I sense exists. So let me explain what I mean by that. So you can think of companies as a unitary actor, like in a microeconomics model that maximizes its profit regardless of whatever the institutional environment is. You can think of a company as a group of people who are stuck in an economic system whose imperatives override their instincts to be ethical. You can think of companies as people who are both economic actors and part of a society that abhors violence against women and would be inclined to work hard to prevent that, even from within their company that's subject to these economic forces. And you can think about companies as full of people who worry about their reputational risk and for whom these soft law mechanisms might be effective in influencing their behavior. And we all bring some version of those implicit assumptions to the way we think about these issues. The use of the phrase corporate impunity or complicity throughout the paper, I have to admit, sort of rubbed at me a little bit because to me it seemed to imply that this was something that these companies are, or that most of the companies are turning a blind eye to or are sort of happy not to address, which I don't think is the case. The companies that I work with devote tremendous amounts of resources, starting with hiring us, to try and prevent a whole raft of problems, one of which is violence against women, but includes all sorts of other discrimination against women in the workplace, child labor, bonded labor, human trafficking, other kinds of religious and ethnic discrimination in the workplace. They have very expensive and sophisticated programs to try and address these issues. They are fully aware of the risk that security forces purporting to act in their name sometimes do awful things. Some of it's violence against women, and some of it's just killing people. And the people that I work with, and again, I might not be seeing a representative sample either, are horrified by this. And so I think these soft law mechanisms like the ILO standards, the Declaration on Human Rights, Aboriginal rights, all this stuff, they take these things very seriously. So while firmer, more enforceable standards would probably do even more, I sort of reacted to two notions. The notion that that this was something that companies were not fully vigilant about, and that these soft law mechanisms aren't necessarily terribly effective. I think in particular, being associated in the public eye with things like this is something that companies hate. And there are people within the companies who hate them on purely ethical grounds. And so I wouldn't underplay the value of these soft law mechanisms. That said, I thought the parts of the paper that talked about the association between natural resource extraction and violence against women were essentially in the diagnosis of the problem and teasing out the problem were really insightful. I do think these man camps, for example, invite all sorts of social dysfunction, including drug and alcohol abuse. You put really sort of lots of men with nothing to do and lots of money in a place, and you see sort of problems arise as a result of that. And you combine that with sort of the weak governance, and you have, so I think that connection, that part of the argument made sense to me. I think there's even more you could add to the paper on this. There's a literature on the resource curse, a guy named Michael Ross. I don't know if you're familiar with his work, but he's got a book that really emphasizes how resource extraction investment in the developing world it raises up the sectors of the economy that employ men at the expense of sectors of the economy that employ women. And this creates additional sort of inequality, exacerbates the very problems you're talking about here. On the other hand, that same literature really taught, his book in particular, but lots of that literature really focuses on the governance institutions in the state as being the most important part of the problem. The corruption, the weak legal institutions. And there's a school of thought that company CSR programs might be part of the solution. And that instead of thinking of companies as these sort of actors that are just trying to maximize profit, enlisting their help in addressing these sorts of problems might be helpful. So ExxonMobil, for example, has for about 10 years, had a pretty well-funded program on women and girls' education and also empowering women-owned businesses in these countries, explicitly based on the theory that when you empower women in these societies, these sorts of social norms improve and mores, the sort of negative mores go away. And so personally, I wouldn't discount the effectiveness of those sorts of avenues of a solution here. I think the arc of this industry, I don't know how long I've been talking. I know people want to talk. Other people want to ask questions, so I'll try to wrap up. But I forgot to look at the clock when I started. I think the arc of this industry, as many sort of negative incidents as you can find still today, the arc of this industry is toward improvement. Back in the day, these relationships between the investor-owned companies and the local governments and local societies was even more exploitative than it is now. And the sort of bargaining leverage is shifting. That at the same time, we still have lots of these countries with more bargaining leverage who are run by corrupt regimes, with weak institutions, and so we still have a lot of these same sorts of problems. But I think my general sense is that it may be that some of these companies, and I was in the article, there's sort of a really dismal portrait of Canadian companies in particular. That Canadians are nice thing, sort of shattered. But I think we should not necessarily dismiss out of hand the possibility that companies and company efforts, because these are oftentimes extremely influential actors in the places where these projects are built, if they can be enlisted to do the right thing and to help be a part of the solution, that might be effective, especially if you think that the probability of enacting binding standards into international law is low. And I have no idea how low or high that is, but if you think it's low, then maybe we ought to be looking at this other avenue of a solution as well. I'll stop there because I think we probably want to ask questions.
So we now open it to questions. So if you could take the front table, that would probably make it easiest to field and respond to questions. By convention, we offer the students, so this is part of a semester-long seminar on natural resources and human rights. And so we give the students the first shot at asking questions. The students are roughly distributed in these tables. And so if you'll, Penelope, if you want to just sort of acknowledge questions.
Yes.
And we'll let the students take the first round or so of questions, and then I'll open it up to the rest of it.
Hi. So this question, I guess, is for both of you. Mr. Spence, from what I take it from your response, you believe very strongly in the ability of corporate social responsibility to actually further human rights motives and as a mechanism to actually increase human rights throughout in these places. I take a more critical stance of corporate social responsibility because I notice that these corporations exist in a system of capitalism based on exploitation of whether it's cheap labor or cheap fuel or cheap resources. Certainly a Marxist approach. But my question, I think, is also for Ms. Simons, is that you seem to believe very strongly in more international regulation through a neoliberal system. And so I'm sort of thinking about how can we bridge the gap between these two sort of systems into one that is more equitable, into one that actually does address the exploitation of workers in general.
I think that's a very good, is that on? Okay, that's a very good question. Like how do you address this gap? But I think perhaps Professor Spence's comments, I think, you know, there is probably a happy medium, and I think that's what we are doing at the moment. That's what is happening at the moment, is corporations are doing what they do, and people are trying to pass regulation, whether it's domestic or international, in various countries, or in the, you know, at the United Nations. They're trying to get a treaty which is going to help, hopefully, to address some of these concerns. But in the meantime, a lot of it is about raising awareness about these things, pressuring companies at their annual meetings when they do, you know, when Barrick, for example, gets involved and does nothing about these rapes. Pressure at their annual meetings, and using reports like the Justice and Accountability Project report. All of these things are ways of raising the issue in the public sphere, and then pushing companies to then engage in some of these things that Professor Spence was talking about, which I think, without the kind of pressure that comes from that, we wouldn't be where we are if there hadn't been all of these groups raising this issue. So I see that as a happy medium, bringing cases against companies where they have engaged in grave violations, you know, of human rights. And that is the way of, you know, because I think it's a long project to expect us to evolve. We now think that corruption should be regulated. I mean, the anti-corruption should be regulated. We've done that. That took, you know, 30 years or whatever, and there's no reason why we now can't say, oh, okay, so this is another thing that is something that we value the protection of human rights and the protection of women's rights, and we should be doing something again about this issue.
Yeah, I thought of the OECD Convention on Bribery as a model for kind of what you were saying, which it sounds like that is what you were thinking.
Yes,
something like that, where they sign the treaty, binding national law, then follows. And, yeah. To answer your question, I think you're right. First of all, I'd like to echo what Professor Simon said, that often these things are triggered by some sort of exterior stimulus. Could be pressure from an NGO. It could just be a huge accident, like Exxon Valdez, for example. Exxon now has a safety record that is mind-blowingly good, you know, way better than everybody else in the industry, because they were so traumatized by the Exxon Valdez accident. Shell made a mess of things in Nigeria on many different fronts, environmentally, human rights, and and corruption. And that experience is what really drove a lot of the Shell corporate social responsibility policies that followed. In other industries, you see sort of public embarrassment, not necessarily, well, sometimes caused by regulation that discloses something, and sometimes caused by NGOs. As I said, I grew up in Rochester, New York, where when I was a kid, Eastman Kodak was the big employer. They're pretty much no longer, but when the U.S. government passed a law just requiring them to report how much of certain chemicals they used in their manufacturing process, not requiring them to reduce them at all, just report it. They were so embarrassed by the numbers that they were using in their manufacturing plant that they cut those emissions by 90%. So I think public pressure, is definitely part of what motivates CSR. I think nowadays you also have a mix of people who are motivated by that desire to protect their reputation and the long-term, what they would call the long-term license to operate, and also just people who there are people who actually want to do the right thing, believe it or not, in these companies.
And just press is a concluding observations from the Committee on the Elimination of All Forms of Discrimination Against Women that was reviewing Canada's most recent periodic report. And they have spoken about concern about the negative conduct of Canadian companies, the inadequacy of the legal framework in Canada to deal with Canadian extractives operating abroad, and the limited complaint mechanisms that exist, and have called on Canada to strengthen their legislation, which I guess is another word for put in place some legislation, introduce effective mechanisms such as an ombudsperson, so they're directly supporting this call by NGOs for an ombudsperson, adopt measures to facilitate access to judicial and administrative remedies. So this is another form of public pressure, these sort of soft recommendations that come down from these committees that monitor states' compliance. And with a government like we have now, which wants to be seen as an international player promoting and protecting human rights, this type of thing might have some traction.
Hi, Professor Simons. I want to ask you to develop more on the third pillars of the guiding principle, because it seems to me the remedy part require both the states and also the corporations to help at least help those victims to get access to the remedy. So how that can help with developing the direct obligations of the multinational corporations?
Yeah, that's a good question. So the third remedy deals with the third pillar deals with access to a remedy, and it suggests that corporations should develop operational grievance mechanisms to not necessarily to act as a full remedy to victims, but to take into account what might be happening and give them a heads up that these things are happening in relation to their project, and deal with it both ex post facto and then preventively going forward, and to compensate victims. It also requires states to provide independent, non-judicial mechanisms for complaints and to open their courts to to allow complaints to go to courts but the way that they're framed, it's still, they're framed as if those remedies should be in the host state, even though you can interpret them as requiring the home state to do that, which is slightly problematic in the way they're framed. You can infer from it. I think he was being very careful because he took a very conservative view of international human rights obligations in the guiding principles. So does that answer your question?
I think that's serves the basis to develop the direct obligations to multinational corporations, because they also require to somehow help those victims get access to how much obligations they have from them.
Sorry, the corporations or the well, it's to develop these grievance mechanisms. So in other words, but the aim of that is to keep companies apprised about what's going on and alert them to things that are going on and provide remedies where necessary, but they're not supposed to be doing what Barrick did, for example, which is requiring people to waive their rights to sue after that.
So my thing is like, I have the feeling that after all we've heard, this is too little. Like, even if you have in place mechanisms that will make corporations liable in Canada or somewhere else, it's too little. That would not make corporations change the way they do. Like if they have to pay some little amount of money to a person in Guatemala after 10 years of litigation, like in the meantime, they will go to the other country, they will do it, and if it happens, it happens, because then all the remedies we are seeing, there seems to be not enough to change corporations' conduct. And I do understand, as Professor Spence saying, that maybe corporations have the idea that, well, there's a lot of things going on in the host countries that they cannot change. So they just do their best in the context in which they are, and they are not responsible for changing the world or something like that. They work. So, and I'm also worried about, especially what it was mentioned, I think that's really important about, I mean, this is gross violations we're talking, but also about this idea that corporations or in the extraction industry, you have the work conditions are being really important to foster gender inequality. Like main camps, I mean, not only people are being raped, but you have the main camps, a lot of sexual workers around it, only male-dominated working fields. So I have also the sense that the governments, in that sense, maybe they have a lot of, are taking in the last years, fortunately, some legislation against violence in women, but then it comes to labor conditions. So a lot have to do with the labor conditions. And if there's anything to tackle this is a structural way in which natural resources are extracted, natural, like the way labor is structured and organized, and if we should now be looking more to that.
Well, I don't know if I have an answer to your question, but I have a reaction. The companies that I'm familiar with, I don't know if this is, yeah, the companies that I'm familiar with will react differently to the kind of, you just described a set of problems associated, for example, with man camps. They react differently to those situations depending upon whether they're in a country that they think has strong legal institutions and will police things, is able to police it, versus whether they think they're in a country that isn't able to do that. So I know of big projects where they built man camps that included all different kinds of entertainment. They spent extra money on, a soccer field and a theater and bars in a Muslim country. So things like this to keep them entertained in the man camp, so they wouldn't go into town, looking for a drink or something else. And so, whereas in the United States, in say the Bakken Shale, they don't necessarily do that, and some of those problems you described, including human trafficking for sex workers, happens there. And so they're looking to the state or the federal government to police that in those situations. Again, that's not an answer, but it's very.
Yeah, and I don't know if I have an answer either. I mean, I do agree. I think we talked about this before, that it is too little. You can't just, law is not the only thing. Law has to be implemented and it has to be followed and enforced. So, but I also think that if you target, various levels, so international, home state, host state, everything, then you have a better chance, and also using soft norms, a better chance of changing how corporations operate, and what their impact might be in these different contexts.
Well, my question is to you, Professor Simmons, about the international human rights obligations. You were saying that there are some developments to be made, not only this resolution that is being taken in the United Nations environment. I was thinking, like, why do we need more international human rights framework, even though when it be like welcome, why it's not enough what we have already, like Inter-American Convention, ICCPR, why is not enough to make transnational corporation compliance, why due diligence of a state are not, is not supposed, I don't think it's that necessarily what you tried to say before, but I was thinking that from my point of view, human rights obligation from states and from are necessarily irradiating transnational corporations, and now states might look forward to their compliance to international human rights standards. That's one thing that I was thinking in your presentation. Maybe I didn't get it correctly, but I thought that you were trying to say that there are like more development in the international human rights law that to be developed, and I think that sometimes that also promotes soft law and more soft law, and that kind of soft law is not helping to make them compliant. And I have like another short question to Professor Spence about the reputational veil that corporations try to work with, and for instance what Barry Gold in the case that Professor Simmons were presenting, it's kind of this veil that make all these great impressive things that they try to do to make everything looks incredible, as the World Bank and IBD and all these grievance mechanisms that lead to nothing. And I was thinking what it takes to a corporation to be having in mind or considering human rights frameworks or obligations, if it is certifications, or how do you see that from your background?
Okay, thanks for that question. I think what I thought you were saying, just to make sure I'm correct, is that why do we need more international human rights law? International human rights law, it already exists, in a variety of places. We've got universal treaties, we've got regional treaties, we've got regional courts that create binding law. Why do we need another treaty? One of the reasons is that international human rights law does not impose obligations directly on corporations. And that's one of the things that people want the treaty to do, that is eventually negotiated, to impose direct binding legal obligations on corporations. And not necessarily an international mechanism to enforce that, but that something then could be enforced more easily in courts if you can show that they have this obligation. There's something that you might be able to enforce in domestic courts. Also, an obligation on states to regulate these corporations, because international human rights law is very sort of territorially constrained for the most part. It doesn't require states to do much beyond their boundaries unless they have somebody who's subject to their jurisdiction. So you need something that says to states that you have obligations that actually follow your companies, that we're living in a globalized world, so it doesn't make sense to have these very sort of constrained. Does that help?
And I took your question to be sort of how do you make sure that a company's corporate social responsibility programs are actually real as opposed to window dressing, or in the environmental side they would call it greenwashing, right? So you mentioned third-party certification. I think most of the big, I don't know much about mining companies, let me just say that. I know a little bit about oil companies, oil and gas companies. I think most of the big oil and gas companies follow most of the major certifying entities, both on the environmental side and the labor and human rights side. But there's still a lot of variety in terms of how much companies put into these sorts of programs. And frankly, the companies that come to us and are willing to pay for executive education are probably doing pretty well. And so they probably have resources to spend on the CSR side of things to minimize, both to do the right thing and to minimize their risk, right? Whereas there are probably lots of competitors or other companies out there that either aren't as far along the learning curve or don't have the resources to invest in it, or feel these economic pressures that you talk about much more severely because they're not competing as well in the market as these other companies are. This is one of the things that goes by the wayside when, along with compliance generally, when markets go down and industry is in decline. We saw that in the manufacturing industry in the United States. As it declined, the environmental compliance records got worse and worse because they just didn't have the resources to have someone pay attention to that full time. So I think the most successful companies are, I can't prove it to you, but I can tell you that it's my belief based on working with them that these are real programs that are actually implemented down the company chain. These are huge organizations with 100,000 employees worldwide. So their level of performance will not be perfect. There will be mistakes, there will be violations, there will be subcontractors they don't police very well who do bad things. But overall, these are real programs, and there will be other companies out there who just haven't gotten on board with this yet, or who would like to get on board but can't bring themselves to spend the money to do it because of the competitive environment.
This is a comment for Professor Spence, and it goes back to your comment on public outcry being a main driver of CSR. With the unique nature of the extractive industries, where the company that's extracting is often not the companies that consumers buy from. What are some ways that we can increase supply chain transparencies? Do companies do it on their own, or should we have outside NGOs that kind of spotlight the supply chain down the line?
Yeah. You just suggested a reason why it's a bad idea for integrated oil companies to be integrated all the way up and down the value chain. So you can go to an, you can still go to an Exxon, you can still go to an Exxon station and buy gasoline, even though the gasoline, that you're buying it from a franchise who, you know, just bought the Exxon name, and it comes from a refinery where crude oil from all different companies came in and was mixed up as a fungible commodity and came out to the various gas stations. So you're right that there's all kinds of breaks in the chain there between the consumer and assuming the misbehavior is in the upstream part of the business at the production area. It's hard to punish the company unless you punish their retailers who then pressure, who aren't actually the company. Sometimes they're good-sized companies, but sometimes they're mom and pop organizations. There's a great book called I'm going to forget the name, but it's a woman who maybe 4 or 5 years ago traced the oil from her local gas station all the way back to the production area and all the chains in between, and sort of illustrated this point. I think most of the pressure on the big companies for upstream misbehavior comes through the mechanisms that Professor Simons just described, which are organized efforts to pressure them, and with the internet, they're very organized across many jurisdictions. So Shell's misbehavior in Nigeria is hurting Shell in Ireland, where they're trying to run a pipeline through a rural area. And Nigerians are coming to Ireland to help the locals sort of organize and oppose the development. And with the internet, that sort of thing is extremely efficient. I've kind of rambled and didn't answer your question, but I don't have more of an answer than that. Sorry.
Okay, I think we're out of students, so we can go.
Thank you. Two questions for Professor Simons. Would you think this is, kind of a different versions from both of you? Is this a few bad actors in a few bad host countries that are causing the problem, or would you say it's a really pervasive problem in a large number of areas? And the second question, I guess, for both of you, I'm not that familiar with like the Trans-Pacific Partnership Agreement. Does that address any of these kind of issues?
I don't know the answer to that one. In terms of a few bad actors, I think it's more than a few bad actors. There are some companies, like Talisman, for example, after they got involved in Sudan, became a poster child for CSR. They have kept a very low profile since then. They've been bought up by another company. But I don't think it's just a few, because there's so many incidents in Latin America with Canadian corporations in particular, extractive corporations becoming involved. I think it's more than a few. It just makes me think of all the comments about I guess it was the film The Corporation, where they kept on talking about a few bad apples, a few bad apples. Has anybody seen that film? No, The Corporation? Oh, that's a really good film. But I think it's more, and I think it has to do with some companies wouldn't pay it, like extractive companies range from ExxonMobil, which is massive, or Barrick Gold, to 3 engineers and a couple of other people going down to look for sort of resources in a particular area, who may have had no experience nobody has ever brought that up in relation to their project. But I think the problem, what I see as one of the big problems, is the corporate form, which originally was created to protect individual human persons who were investing in it, to now protecting these corporate groups with limited liability and sensitive personality. Maybe there are situations when we shouldn't have that, right? When they get involved in these types of abuses. So I think the corporate form allows a more cavalier way of acting, because the risks are downloaded then onto tort victims or what are involuntary creditors, I guess, in these types of cases. But I actually don't know the answer to the question about the Trans-Pacific Partnership, unfortunately. So.
The only thing I would say is that I found myself when I was reading the paper making a distinction between two sort of categories of misbehavior. One was the misbehavior of the workers, and one was the security forces. To me, the security force examples, there's lots of them. You know, I think ExxonMobil in Indonesia, they had a problem with that. Total in Indonesia, or maybe it was Malaysia. Those are very high profile. I don't know how common those are, but almost any time you have a big work camp with thousands and thousands of people in it in a poor country, some of these things, not necessarily sexual attacks or rapes, but other kinds of just things we don't want, criminal behavior of various kinds, almost is really hard to prevent. And that seems to me like if I was to try to guess which is more common, I would think that was for example, sex workers coming and human trafficking and especially depending on the country, child labor, bonded labor, and these are contractors, not necessarily the oil companies. So sometimes they're local because the deal with the country insists that they be local companies, and they have sort of local norms about these things that are different. And so the multinational, it's a principal agent problem. It's really difficult for them. I don't know if I've just made the case for them not going in.
The no-go zone.
Yeah, the no-go zone. Yeah.
I wonder if, since these international investment treaties basically require the host country to use arbitration for disputes, is there any thought, has any thought been given to enlarging the subjects of arbitration to include some of the issues that you're referring to?
Yes. In fact, the second book that Daniel mentioned, Integrating Sustainable Development into International Investment Treaties, contemplates how investment treaties can be reimagined to include, I guess, to first of all increase policy space for states, but also to include obligations for non-state actors, the investors, when they're operating in those cases, and then to include complaint mechanisms and counterclaim mechanisms that would allow states and victims, alleged victims in these countries to bring cases against corporations or investors. So there is, there is a literature on that is emerging.
Has it worked anywhere?
Well, it's that, let me see. So 10 years ago, people thought it was a crazy idea. Now there's a whole backlash against international investment agreements, so it is being contemplated. Some states are not allowing binding arbitration. They require disputes to be settled in their own courts, as opposed to having this international mechanism that allows the investors to bring them to binding international arbitration. There have been some changes, and actually that's a project that's kind of on the sidelines for me that I haven't sort of kept up with. There have been a few developments but I don't think they're radical yet. I think that will take some time, and there's a lot of resistance into people would see this as turning it into a treaty that promotes human rights as opposed to what it's supposed to do, which is to protect investors. So there is resistance to it as well. But
Thank you.
I guess I have a question moving from we spoke a little bit on how there's this movement of people sometimes trying to get corporations to be accountable, and we spoke, I think you mentioned Ireland and how they're facing backlash there from people. do you think that, I feel like there's been an increase in certification programs as far as, that kind of seems like an intermingling of this idea of people being socially aware of what's going on, and transnational corporations agreeing to, hey, if we can get this stamp on our product, it lets the consumer know that we're following these standards or something like this. And if we violate it, then based on these yearly audits or something like that, we lose the right to put the stamp on there. And so I guess that's more of a ideally consumer driven, hey, there's more information, you can pick and choose which corporation is adhering to these guidelines and policies. Do you all think that's I guess I don't want to say worthwhile effort, because I think it seems like it would be, but is that the best way to do it, since litigation seems to be struggling? Everyone, if it even gets there, they just settle, and so you never get precedent out of it, or we just see companies acting and just ignoring what's going on because the host country can't act. So I guess I just want to hear your thoughts on, if you have any thoughts on certification and how that plays into holding transnational corporations accountable.
Well, I certainly, I think it's absolutely of value, as long as these certification schemes are good and there is monitoring and oversight. It's certainly one addition, but I don't see it as, I don't see any of these sort of avenues as the only thing that we should do. I think that you need to have this kind of very complex, multi-partite approach to this, right? So we need to have people bringing cases. We need to have public pressure. We need to have certification types of schemes. We need to have soft law principles that are influencing companies, and we need law. I think we need all of it. We need to keep pushing for all of these things to help change the norms by which we act in these situations.
So I don't know that there are, for the oil companies, there are a lot of environmental certifications. And then there are conventions or standards that they pledge adherence to. And these things are proliferating all over the place, and so they have to choose sometimes which set of standards they're going to follow. And that's why I mentioned the ILO, because I don't think it's a certification, is it? I mean, the ILO is a set of standards on workplace, human rights in the workplace, or worker rights. And it's incredibly useful to the companies. They cover there's very specific guidance in all sorts of thoughtful guidance in all sorts of areas. So just to give you a flavor, so for child labor, for example, our standards of child labor, how we might think about child labor might be very black and white in certain ways. The ILO standards will talk about how, in some of these places, the only place they can get schooling is at these places where they work, say 14, 15-year-old kids. There's, I think, below 14, even the ILO has a hard and fast standard, but that, if a company can provide schooling that wouldn't otherwise be available, and if the job is such that it's not condemning them to a life of stitching soccer balls together for the rest of their lives, but instead is a path to improvement. There's all this sort of nuance to the ILO standards that is really helpful for Westerners going into a country, assuming they should go, Westerners going into a country trying to grapple with, a norm there where 12-year-olds work in these factories, right? So I think they're good in that sense, but I don't think there's any certification or standard that I'm aware of for violence against women, except for these things that you cited, but they're not really that's too big an issue to try to have a certification for, I think.
All right, one more. We've gone a little bit past our normal time, but Apostle, so you have the last word on it.
For Professor Simons, I'm curious, when you kind of went through and you said that the corporate form is really what kind of insulates a lot of these larger parent companies from liability, I'm curious, to reform it, I guess at the home state level, how broad or narrow would you want it to be? Would it just be, like, for instance, transnational corporations that are engaged in extractive purposes, or would it be basically reforming the entire corporate governance structure of these countries?
I think you can only start with narrow reforms. You would have to, the reform that I would see in relation to transnational corporations that should happen in, say, Canadian corporate law would be that parent companies and directors and officers are liable for the acts of the subsidiaries and contractors in these certain situations. So parent company liability for that. So if somebody brings a claim against a company, they don't have to prove somehow that the parent actually controlled every move of the subsidiary, or they don't have to show that the parent acted by its own acts or omissions, committed these acts or caused the harm. But that the parent company is liable when something happens. But I would say be a narrow reform. But we lift the corporate veil legislatively for certain things that we think are important, right? So there's no reason why they can't do it for these types of violations, for this particular circumstance. I mean, and in Canada, it's an issue with all transnational corporate activity, but the extractive sector for Canada is really key. So I would say start there, and then once that takes over, because the broader changes if you try something too large at once, it'll be completely rejected. So you have to start small.
Thank you both for a really engaging set of talks and a conversation with the audience. Thank you all for being here. And on behalf of the Rapoport Center, thank you for attending from time to time. Our speaker series, we're wrapping it up for the year, but we'll have more in the spring on these and other issues. So thank you all again.